Good morning, this is your Kelso Report for Thursday, September 27th, and I'm your host, Clark Kelso. Our cases today include the proper interpretation of the commercial activity exception under the Foreign Sovereign Immunities Act, the authority of the Forest Service to restrict motor vehicles from portions of the El Dorado National Forest, the proper use of Chevron deference in an immigration case, and the extent of conservator immunity for injuries resulting from the acts of conservatees. We begin with foreign sovereign immunities. One of the attributes of sovereignty that is recognized by our courts is that a sovereign generally cannot be sued without its consent. That consent is generally reflected in statutes enacted by Congress or by state legislatures. And in the case of suits against foreign countries in U.S. courts, Congress has enacted the Foreign Sovereign Immunities Act that tells courts when they have jurisdiction to entertain suits against foreign countries. As a general matter, the Foreign Sovereign Immunities Act grants jurisdiction only if the foreign sovereign has itself waived its immunity, or, as a substitute for that waiver, if the foreign sovereign is engaged in commercial activity within the United States, and the cause of action bears a nexus to that commercial activity, or if the foreign sovereign commits a tort against someone within the United States. In Sachs v. Republic of Austria, the plaintiff had purchased a Eurail pass in California from Rail Pass Experts, a Massachusetts company that is owned by some 30 European railway companies. One of those owners is the Austrian National Railway. The plaintiff was seriously injured when she tried to board a moving train in Innsbruck, Austria, and fell through a gap in the platform. She sued the Republic of Austria, which owned the railway. The only issue before the Ninth Circuit was whether jurisdiction could be established under the commercial activity exception in the Foreign Sovereign Immunities Act. The majority of the Ninth Circuit panel held that the commercial activity exception did not apply and affirmed dismissal of the action. One of the judges in the majority reasoned that the Austrian National Railway did not have sufficient day-to-day involvement in the Massachusetts Marketing Company so that its sale of the Eurail pass to the plaintiff could be imputed to the Austrian National Railway. The second judge in the majority reasoned somewhat differently that even if the sale of the ticket could be imputed to the Austrian government, that commercial activity did not have a sufficient nexus to the tort and the plaintiff's injuries in order to trigger the exception to sovereign immunity. The tort and the sale were simply too remote from each other. Well, under either rationale, the plaintiff's suit was properly dismissed, and the plaintiff's recourse now is to sue in an Austrian court, if that's possible. Next, we turn to national forest regulation. One of the distinctive features of the western part of the United States is that large tracts of land are still owned and regulated by the federal government. That power to regulate routinely brings the federal government into conflict with people who have grown accustomed to using that federally owned land for their own purposes. In Public Lands for the People versus United States Department of Agriculture, the conflict was between modern-day prospectors for gold and the United States Forest Service. The service had decided to limit the use of motor vehicles to certain roads in the century-old El Dorado National Forest. Well, that regulation substantially restricted the prospectors' access to mining areas, where, given the way mining is done today, motor vehicles and heavy machinery are required. The district court held the service had ample regulatory authority to issue the motor vehicle restrictions, and the Ninth Circuit easily affirmed. The Organic Administration Act of 1897 gives the Secretary of Agriculture authority to promulgate rules and regulations to protect the national forest lands from destruction and depredation. Although nothing prohibits an individual from entering national forests for all proper and lawful purposes, including that of prospecting, locating, and developing the mineral resources, people who enter those forests must comply with the rules and regulations covering the forests. Well, that broad grant of authority gives the Forest Service all of the power it needs to enact reasonable rules limiting motor vehicle access to various parts of the El Dorado National Forest. The prospectors are simply going to have to go elsewhere or go back to a simpler way of searching for gold that doesn't involve the use of motor vehicles and heavy machinery. Good luck with that. Next, we have an immigration case. One of the most important principles in administrative law is that courts ordinarily should defer to an agency's interpretation of its own organic statutes and regulations. This is known in the context of federal administrative law as Chevron deference. The applicability of Chevron deference was the real issue in De Osorio versus Mayorkas, which deals with the eligibility of certain children for expedited visa relief under the Child Status Protection Act. The appellants in the case had become lawful permanent residents and immigrated to the United States. However, due to visa quotas and a serious backlog, by the time the appellants received their family-sponsored visas, their children were no longer eligible to accompany them as recipients of derivative visas, which are available only to children under the age of 21. In essence, the children had aged out of eligibility because of the delays. The Board of Immigration Appeals held that under the applicable statute, the children were not entitled to expedited relief. The Ninth Circuit, in an in-bank majority, 6-5, read the same statute and concluded that it was unmistakably clear that the Immigration Board was mistaken in its interpretation, and so it refused to give the board deference and decided the children were entitled to relief under the Child Status Protection Act. Well, the 5 judges in dissent noted that the applicable statute was almost certainly ambiguous, particularly since there was a split between the other circuit courts in how to interpret the act. And given the ambiguity, Chevron deference should have applied. It does seem to me that the dissent has the better argument here, and since the case is more about the applicability of Chevron deference than about the interpretation of a particular immigration statute, it would not surprise me to see the Supreme Court grant review to re-emphasize the importance of judicial deference to administrative agency interpretations of law. Finally, today we have a state law case involving the immunity of a conservator. Statutes that provide immunity from liability for what otherwise would be tortious conduct are often difficult for courts to swallow. When a person has been injured as a result of unreasonable conduct, basic principles of justice, not to mention years of training in law school, have taught lawyers and judges to look for some way of making the wrongdoer responsible for damages. That is, I think, pretty clearly what the Superior Court did in County of Sacramento versus Superior Court, a case that presents admittedly strong facts for liability. The defendant in the action is the County of Sacramento, whose public conservator allegedly failed to warn a care facility adequately about a conservatee's history of violence. Because of that failure to warn, the facility did not adequately prepare itself, and the conservatee injured one employee and killed another. When the county was sued in tort, it asserted an absolute immunity pursuant to Welfare and Institutions Code section 5358.1. The trial court, after finding the existence of a duty to warn, ruled that the immunity is not so broad because there is a duty that in essence supersedes the immunity where someone is a real problem and dangerous to the public. Well, this rather weak reasoning did not survive a writ of mandate which the county took to the 3rd District. The statutory language could not have been clearer. Quote, "Neither a conservator, temporary conservator, or public guardian appointed pursuant to this chapter shall be held civilly or criminally liable for any action by a conservatee," close quote. The plain language here was not ambiguous, and even when the court took a peek at the legislative history, it did not discover anything to suggest limitations on the immunity. The Superior Court simply got it wrong and essentially disregarded the clear statutory immunity. The case is going to be dismissed. That's it for today's Kelso Report. Have a great day in the law.